Thank you, Mr. Clark. Gentlemen, welcome to this, and we welcome any of the viewers who are watching our live stream here today. Gentlemen, we appreciate your participation here today in something that this court has never done before, and that's the live streaming of arguments to the people of Tennessee and elsewhere. So it's been a good day for us. We've had 2 cases already. This is our 3rd case of the day. We understand that this is not an optimal situation for everyone, but we also understand it's not a perfect process. So please don't feel like you have to be perfect, and we will not be perfect either. So as we go through here, we will try our best not to talk over each other and try to identify ourselves so you'll know which of us is asking questions if we are. But we will move forward in that way. So when we do begin, as usual, each side will have 30 minutes for argument. If you're dividing your argument, please let us know how that division will be done when you begin your argument. And also, if the appellant wishes to reserve any time for rebuttal, please do that at the beginning of your argument too. All right, Mr. Clark, will you call our case, please?
Scott Trent et al. Versus Mountain Commerce Bank et al.
Okay. Mr. Phillips, understand were you going? Who's going first here?
May it please the court, if the court's ready, I am William Phillips of the Hawkins County Bar, and I represent the appellants in this matter. I think we have an issue of first impression, perhaps, for this court in one instance, and in one instance not. Perhaps the issue that we have is whether or not the equitable remedy of reformation can apply to a written instrument, in this case a deed, where one of the parties was inadvertently excluded by mutual mistake.
Mr. Phillips, before you go further, do you wish to reserve any time for rebuttal?
I do, Your Honor. I'm sorry, 5 minutes.
All right.
The facts of this case are important, and I'm going to review those as briefly as I can with the court. I'm sure the court's probably familiar with it, but at any rate, Mr. and Mrs. Adrian Green were the owners of various parcels of real property in Hamlin County, Tennessee. Her first name is Pamela. Back in March of 2010, they made the decision, along with a limited partnership, to convey their interest in 12 different pieces of property to 2 different limited partnerships. The one that's in question is Real Estate Holdings of East Tennessee. In conformity with the agreement, the Greens took their 12 deeds to their attorney's office and said, we want you to prepare quitclaim deeds to these 2 limited partnerships. Some of the properties were owned by Mr. Green by himself. Some were owned by Mr. and Mrs. Green as tenants by the entirety. The particular piece of property that's in question was owned by them as tenants by the entirety. Unfortunately, the attorneys, when they drafted the estimates, left Mrs. Green's name off of the deed that went to Real Estate Holdings. They went to the office, signed all the deeds, assumed they were drawn correctly. They wouldn't know any differently. And the deeds were then executed, were placed of record. Nothing was discovered.
When you say wouldn't know any differently, surely Mrs. Green knew which parcel she was or was not an owner of, wouldn't she?
Well, she may have, but when all of the 12 deeds were prepared, the lawyer said, here are the deeds, you signed them. She signed it. I don't guess she questioned whether or not this particular deed, it didn't have her name on it, and she made no question of that. So several years later, 7 years later, it was discovered that this was a mistake, and a deed of correction was entered into by Real Estate Holdings and the Greens, which said, hey, we made a mistake. We want to correct that mistake. Mrs. Green's name was inadvertently left off. That deed of correction was recorded. In the interim, the respondent banks recorded judgment liens against the Greens, and that's why we're here today. The judgment liens were recorded approximately 2 and 2.5 years after the March 2010 quitclaim deeds. A declaratory judgment was filed in the Chancery Court for Hamlin County. Judge Gene Stanley sat by interchange and heard the testimony. At the conclusion of the testimony, she determined that there really was no question about the facts. The facts were that the Greens intended to convey their interest, that Real Estate Holdings intended to acquire that conveyance, but that it didn't happen. that there was a mutual mistake. However, Judge Stanley opined that because Mrs. Green was not a party to the deed, that there could not be a reformation. It is our belief that the chancellor misconstrued the doctrine of reformation. The doctrine of reformation, and it's been established in many appellate cases in the state of Tennessee, is that if there is a mutual mistake in the writing that is the embodiment of the agreement that the parties agreed to, then the court may correct the writing so it is the same as the agreement the parties entered into. In this particular case, the agreement was that Mrs. Green was to convey her interest in the property in Mr. Green. It didn't happen on the deed, and so clearly there was a mutual mistake. There have been many instances of mutual mistakes on descriptions of property, even signatures that have been left off of deeds decided in the courts of the state of Tennessee. And
Mr. Phillips, this is Justice Clark. Are there any other cases in Tennessee where the party in question was not a party to the written document?
No, that's why this is case of first impression. So I guess the issue is, and if you look at the definition of the Doctrine of Reformation, the Doctrine of Reformation says that the written instrument is the expression of the agreement. So when the written instrument does not reflect the agreement, that is a mistake in expression which can be corrected by reformation. And that's what should have been done in this particular case. At least that is our opinion. The case of Lane versus Spriggs was a Tennessee appellate case in 2001 where there were 4 deeds drawn. One of the deeds failed to have the signature of the conveyor, and the courts said, yes, that is a mutual mistake, and we will allow the signature of the conveyor to be placed on this 4th deed.
Phillips, this is Justice Page. I don't think I'm muted. That's very different from adding a party, though. I guess as one who used to do title searches, I guess I'm wondering about the sanctity of the title search here. If a lawyer was asked to do a title search on this property for 7 years here, he or she would have opined that Ms. Green still owned part of it, right? And then you have these 2 banks who think they have judgment liens, and if somebody did a title for the banks, they would tell them, yes, you have a valid judgment lien. Correct?
I think that's correct. If in fact the banks performed a title search, and if in fact their judgment liens were premised upon the fact that this interest had not been conveyed, I don't think that's the case. There's no proof that that's the case. And there are some cases.
Mr. Phillips, this is Justice Kirby. To follow up on what you're saying, the title search is actually of more significance to your clients, the Trents. You were the lawyer who documented the transaction with the Trents. You documented the November 2014 deed of trust, the 2016 warranty deed. What you are asking for is equitable relief from the Court of Equity, right? That is equitable relief, and a title search done for your clients, the Trents, certainly would have uncovered the fact that Mrs. Green was not included on the transfer to real estate holdings. It also would have uncovered the intervening judgment liens, the foreclosure liens that your opposing counsel is representing. Under the maxim equity aids the vigilant, why should the Court of Equity give you equitable relief when all of that was there for you to find? The equitable relief is going to you and your client. How were you appropriately vigilant?
Well, I agree with what Your Honor has said, that there certainly might have been a lack of vigilance or mistake made in that particular respect. However, that nevertheless, the current owners or the purchasers, real estate holdings, would have thought that they had acquired, by virtue of the quitclaim deed and or the warranty deed in the latter case, the interest in the property. Whether they did or not.
Sorry, I'm not sure I understand what you just said.
Okay. whether they acquired the interest or not is the issue. Whether
Well,
someone.
actually, I'm asking you the issue about the ultimate issue is whether your client is entitled to equitable relief from the court of equity. I'm asking you if your client exercised vigilance so that you can come into a court of equity and ask for extraordinary relief.
Well, if you assume that my client should have had to perform the title search, and should that have been done, should the title search have revealed the problem?
You are actually on inquiry notice, were you not, of everything that a title search would have uncovered, including the fact that Mrs. Green was not included on the transfer to real estate holdings?
Yes, but I believe that's how it all came to light, was a title search that did discover that.
Mr. Phillips, excuse me, this is Justice Lee, and like Justice Page, I used to do title searches. I did more than I ever wanted to do, to be honest, but your clients presume to know what's in that chain of title, whether they did a title search or not. So when they bought this property, they were presumed to know that there were 3 judgment liens and that Mrs. Green had not transferred her interest in the property. So your clients are coming into Chancery Court with unclean hands. And because of that, they're not entitled to equitable relief. Now, I'm wondering if that issue was raised, and if it was not raised, has it been waived? But that's the sticking point I have in this case, and from reading all the briefs, I couldn't really get to the issue that you were arguing because I couldn't get this out of my mind that at the time your clients bought the property, they were essentially buying a lawsuit. And you can't do that. So help me get around that problem. If
well, I think you have to assume that my clients would be at fault if they didn't have a title search, or if they had one, that it didn't reveal this. But the clients, I don't believe, are at fault.
Well, I know that it's an issue of being at fault. It's just an issue of, we presume they knew when they bought this that there were real problems with this title because Ms. Green had not conveyed her interest. So I have trouble understanding how you buy into a lawsuit like that and then come in and seek equitable relief when you don't have clean hands. And it was not, maybe not negligence, not an intentional act, but based on that presumption of knowing the title, I'm just having trouble seeing how you're entitled to relief.
Well, there are other cases, similar cases in our state where a very similar act has occurred, where judgment creditors have filed liens and the court has said they're not entitled to object to a reformation of it because the judgment creditors lien, they're really not bona fide purchasers. They don't have any skin in the game. They didn't rely on the fact that Mrs. Green did not convey her interest in order to put that judgment lien down.
But these judgment creditors, this is Justice Kirby, but these judgment creditors recorded their lien. It was an both agreed judgments, and they recorded their lien. It was there to be seen.
And this is Justice Bivens to follow up on that. Then you had the situation where the intervening liens were there, and your person was not, Mr. Green was not on the deed. So how could they have even been on any type of a notice that Ms. Green could possibly be involved here?
Well, Mrs. Green was involved as she signed the deed of correction along with real estate holdings.
Well, after the fact.
Yes, that's correct. The point that I'm trying to make is that the purchasers, nevertheless, if they had purchased this property and not had a title opinion done, which they may very well have done, I'm not saying they did or didn't, but if they had, then would they be put on notice? Let's say the title exam was done and this was not discovered, that Mrs. Green was not on the quitclaim deed back in 2010. That still doesn't, I don't think, make Mr. Trent and Mr. Trent having unclean hands in this particular case.
I think they're presumed to know what was in that title exam. If the lawyer missed it, then their claim is against the lawyer for missing it. Now, presumably the bank had a title search done before they loaned money on this property. So
that's presumably that is correct, that they would have had a title search performed. There's no question.
Mr. Phillips, I do want to ask you about the doctrine of unclean hands, though. The circumstances surrounding the transfer of these 12 deeds to real estate holding, when we looked at the record, I noticed that the only testimony in the record was Mr. and Mrs. Green. And I thought, how can you have testimony from only one side? And then I realized, oh, Mr. and Mrs. Green are actually on both sides of this transaction. It was 12 properties bundled together and that they transferred to themselves not too long in advance of these foreclosure proceedings. So, I mean, it gives the appearance that they're trying to shield these properties from creditors. So why should you ask a court of equity, and they inadvertently bungled one of them, why should you ask a court of equity to come to give you extraordinary relief to clean up the one out of these 12 properties that they tried to deed to themselves to another entity to help them clean that up? I'm not sure why you are entitled to extraordinary equitable relief in that circumstance.
Well, Your Honor, that issue was not raised. As a matter of fact, it was not raised nor questions asked. It was not raised in any pleading.
Well, actually, when I looked at the record, it appeared that it was raised to the trial court.
Yes.
The trial court said, well, they didn't plead the affirmative defense of fraudulent transfer, so I'm not going to consider it. But here, your opposing counsel is not trying to get the transaction voided or anything like that. This is just part and parcel of the entire circumstances that the trial court should take into account when it is being asked to give equitable relief to your client, right?
Well, I believe that issue would be an affirmative defense, Your Honor. And under Rule 8 of the Rules of Civil Procedure, that affirmative defense should have been raised in the pleadings. But nevertheless, the trial court just merely said, I'm not going to allow you to raise this. After all of the testimony had concluded, that issue was raised in final argument. And the trial court said, that hasn't been pled. We don't have any testimony really about that. I'm not going to allow you to raise that as a defense at this point.
Well, why do you have to raise a circumstance like that as an affirmative defense when you're asking a court of equity to look at the entire the burden is on you, right? The burden is on you to show that you are coming into court and that you are entitled to extraordinary equitable relief. Why should the trial court not consider if there's a whiff of something that doesn't smell good about the very transaction that you're asking the court to remedy?
And actually, Justice Billings, before you answer that, add to that fact that the whole maximum of unclean hands is to protect the court, is to allow the court not to become involved in something where there are unclean hands. Even if both parties had unclean hands, it would be there. So the maximum is to protect the court, not to necessarily protect any one of the parties.
Well, and I agree, but if there are unclean hands, it's not on my clients. My clients bought this property in good faith. If there's any fraudulent conveyance, and I'm not saying there was, that was done back in 2010 by predecessors in title and has nothing to do with the Trents in this case. So they don't have unclean hands. And
this is Justice Clark. Yeah, but your clients can only purchase what interests are available and have been conveyed by previous deeds. So if this interest was not conveyed, your clients couldn't purchase it. I don't mean that they have unclean hands, but they have no basis because you're presumed to know what interest you're purchasing.
Well, I agree. That's why we are here, to say that it was intended that we purchase the whole interest of Mrs. Green. it didn't happen. If Mrs. Green had some nefarious purpose in her conveyance of the properties, and I have no clue or have no idea if they did, it shouldn't reflect on my clients who now have title to the property.
Mr. Phillips, we may have thrown you a curveball by asking all these questions about unclean hands and going down that path, but was the doctrine of unclean hands argued at the trial court, pled? Was that ever an issue?
No, Your Honor, it was not.
Today? Okay.
It was raised at the very end of the trial when during final argument, attorneys for the respondent said, well, we think there may have been a fraudulent conveyance here. And that's when Judge Stanley said, I'm not going to allow that to be heard. I'm not going to consider that issue because it has not been raised.
Well, but fraudulent conveyance and unclean hands are two different doctrines.
Well, they are, but I suspect one who has fraudulently conveyed would have unclean hands.
Well, that could be one instance of it, yes, but that's not necessarily exclusive.
I agree.
Were your clients questioned about whether they knew the state of the title or did they do a title exam? Was that argument made?
No, it was not. That has not been raised, period, at the trial level.
That's something that can be waived, is it, if it is not raised at the trial level?
I believe so. I believe any of that argument was waived if it was not raised at the trial level.
Mr. Phillips, this is Justice Page. Do you agree that the tenancy by the entirety here was destroyed by the conveyance of Mr. Green's interest, but not Mrs. Green's interest?
Well, they obviously no longer held it together as tenants by the entirety. So all that Mrs. Green would have had is an expectancy interest should she outlive Mr. Green.
Well, I'm asking because we filed a case a couple of years ago, Bryant versus Bryant, where we held that a joint tenancy with right of survivorship was destroyed when one party conveyed her interest and left the parties as tenants in common. So from that case, I'm thinking what we had here for several years were these people operating as tenants in common. So my question to you is, can we, by reformation deed, put a tenancy by the entirety back together?
Well, I don't know that the court would have to do that. I think what we're requesting by way of reformation is that the court just say, yes, we're going to reform the deed because so that Mrs. Green actually conveyed her interest. She conveyed her interest in the deed of correction, and the deed of correction stated this should relate back to March the 3rd, 2010 or March the 10th, 2010, whatever it was.
But that takes us, this is Justice Clark, that takes us back to, it can't relate back to that if there have been intervening creditors who have liens on the property, right?
Well, then that raises the issue of what creditors can you reform against? So that question has been answered at least by the appellate level courts in the state of Tennessee. And it says you can reform against all but bona fide purchasers. And it specifically said in the case of hospitality,
But also, Mr. I'm sorry, this is Justice Kirby. Along those same lines of what Justice Clark was asking, equity, the court of equity generally, if the equities are equal, the court of equity will be in favor of the first in time, and that's not your clients, right? That's the judgment.
That's correct, Your Honor. And the point I was about to make with the hospitality, holiday hospitality franchising is, they said a judgment creditor is not entitled to object to reformation because they have not relied on the title of the property. They've recorded their judgment lien. Their judgment lien would have been recorded whether or not Mrs. Green's interest had been conveyed. So they were out nothing. They had no consideration paid and are not entitled to be in the position to object to a reformation of that deed. And that's the position that we take.
Mr. Phillips, this is Justice Page. Before you run out of time, you've already told us that this is a case of first impression in Tennessee. In other words, reforming a deed to add a party. If we looked at other states, did a 50-state survey, what are we going to find is the prevailing rule?
I think the prevailing rule is, yes, you can. I found a Florida case, Royal Auto Group case, where a party was left off of a guarantee agreement they said, yes, reformation applies here. There was a mutual mistake in that party not executing a guarantee agreement, and they reformed it by allowing that to be done. And I guess really the issue is, where do you draw the line in reformation? Yes, you can reform it by changing the description. Yes, you can reform it by allowing a signature, but no, we draw the line. You can't add a party. If in fact the agreement was that that person was supposed to have been a party, and by mutual mistake they were not.
The agreement this is Justice Clark, the agreement you're talking about was an agreement entered before the deed. And so really that would require parole evidence. The deed is the evidence, and this person is not a party to that deed. I think there are actually a couple of 1920s Tennessee cases from the Court of Appeals, and right now I don't have one in front of me. Nobody cited them, but I think this may have been addressed in Tennessee in that context, where it clearly said if you're just a party to an agreement, but you're not a party to the writing that you're seeking to reform, it can't be reformed.
Well, and that's where I can't see the distinction drawn at that. If in fact the parties agreed that A, B, and C will do a conveyance to D, and B is inadvertently left out, I fail to see why that expression of the agreement, the deed, cannot be reformed. The courts are pretty uniform in saying that a mistake by expression can be reformed, and the deed can be reformed. And so I fail to see the line drawn where you can say, well, we can allow a signature, but we can't allow a party. You're not a party if you don't sign the instrument, regardless.
Right. And so you've conveyed no interest.
That's correct, but which is the purpose of reformation, at least I believe.
All right. Thank you, Mr. Phillips. All right. Who's going to lead off, Mr. Harrod?
I will, Chief Justice. Good afternoon to the court. May it please the court. My name is Steve Hurett of the, I'm an attorney at Wilson Worley Kingsport and a member of the Sullivan County and Kingsport bars, and a Kingsport boy born and raised. And I assure you that my repeated references to Kingsport are in no way an attempt to curry favor with the Chief Justice this afternoon. I represent the interests of First Community Bank, who's one of the appellee banks in this case. I intend to take the lion's share of the argument time and ask that 5 minutes of our 30 minutes be reserved for Mr. Schultz, who represents the other appellee bank, Mountain Commerce. Before I get into argument, and the court has touched upon this already, I believe Justices Clark and Kirby have already acknowledged that about title exams and things of that nature. So I want to delve a little bit more into the facts here. So the Greens acquired title to the 2 parcels in Morristown that are to which we say that our judgment liens attached in 2007 via warranty deed as tenants by the entirety. So there's no dispute there. Now, it was raised about, we've talked about doctrine of unclean hands, fraudulent conveyance, some other things that were not raised except in the trial court. And I think it's clear from the transcript and the record that those were brought forth to the court's attention to lend context, exactly what Justice Kirby had said, which is context to the overall. The whole reason we're here today is because the Trents and their bank and Bill Phillips in his capacity as trustee are asking for equitable relief, yet the whole thing that kickstarted this process was an inequitable act, an effort to hinder creditors, namely my client, Mr. Schultz's client. The Greens testified that they knew foreclosure was coming. They knew that after that would be deficiency actions and subsequently recorded judgments. And that's exactly what happened. The banks pursued their collateral diligently. They obtained their judgments. They recorded those judgments in accordance with 25.5.101, subsection B1, which is the Recording Act. So to allow the appellants now to attempt to reform over top of that, I think serves to only to undercut the recording acts in the state.
Mr. Harris, this is Justice Bivens again, but what about, is it accurate to say that your clients did not raise fraudulent conveyance as an issue in the lawsuit?
I would differ as far as a raised affirmative defense, Your Honor, not expressly, I think, in the pleadings, but if you look at the record in the various trials,
that's where affirmative defenses are usually raised.
Well, yeah, yes, I acknowledge that, Your Honor. But if you look at the evidence that was admitted into the record, particularly the trial evidence, the various exhibits, particularly, The reason why those were brought in, it shows how the Greens created a limited partnership in which they were both limited partners. The general partner of the limited partnership was ASG Holdings, Inc., which is Adrian S. Green. That he was his brother was the president of that entity at one point, and eventually Mr. Green became the president of that entity. So Mr. Phillips has made reference to an antecedent agreement that preceded the written instrument being the deed. The antecedent agreement was not really an agreement at all. It was a closely held, there was no consideration paid for these transfers. There was quitclaim deeds all done and executed on the same day. So to call this an agreement is a bit of a farce, because that's exactly what these folks were doing. They were attempting to hide and shelter property and put it in there. So we talked about equities and balancing the equities, and I think that's exactly what this case is about. And the Trents now are coming back to the court asking for equitable relief, yet their predecessors in the chain of title, I believe, have spoiled that for them by engaging in inequitable acts. And those inequitable acts have to land on someone. So why should they land on the banks who had done nothing wrong other than pursue their collateral, obtain their judgments, and record their judgments?
Well, the unclean hands doctrine that I think applies to the Trents would be their knowledge, their presumed knowledge of what was in the title, sir, or in the chain of title. And based on that chain of title, they were not getting full title to this property. Now, was that issue the issue of what the Trents actually did or did not do in their presumed knowledge, which may constitute unclean hands? Was that raised at trial or in the pleadings?
The Trents did not the Trents did not testify, Justice Lee, at the trial court level. It was raised, and it's, I think, clear from the exhibits that were admitted into trial, particularly the warranty deed from Real Estate Holdings of East Tennessee to the Trents. If you look at the derivation paragraph in that document, they cite to what I would call the deed A, which is the quitclaim deed that kicked this whole thing off. It only references Adrian Green. It does not reference Mrs. Green, but the citation to the recording of the quitclaim deed is correct. So whoever missed this along the way just missed the fact that Mrs. Green was included as a tenant by the entirety. She got left off at some point along the way in the chain. That corruption passed on down the chain, and it was there to be found. It just wasn't found.
Well, was that argument made to the trial court?
I believe it was in the I think it's in the transcript, Your Honor, yes.
Because, I mean, I don't think it's fair for us to raise an issue today that has not been raised previously. But my concern is the Trents had to know the state of the title when they bought the property, and they shouldn't have bought a lawsuit. If that is what happened, then I think that issue had to be raised in the trial court. And I've not read the record yet, so I don't know if that was raised. Do you think it was raised?
I believe so, because there was without objection, the exhibits to the trial were stipulated and let in, and it shows all the various, like I said, there was no reason to bring those into land context of the situation.
But I guess I'm asking, was it pled? Was it argued? And I think you froze up, and
Yeah.
there, you coming back?
Mr. Hurd is frozen.
There he is. Are you back?
Yeah.
Okay,
Yeah, good.
now we can see you
Yeah,
again.
hold on.
I'm sorry, folks. Yeah,
There we go.
Our Lady of the Internet is failing me here. Sorry, Justice Lee. Would you
I
mind
guess,
just revisiting your point there?
and I'm not so concerned as to what the exhibit showed, but what was pled about unclean hands and what was argued to the trial court. And if you're not certain, we'll find it in the record, but I'm just wondering, was this
I
an
think
issue
it'd be
in the trial court?
I think it probably was raised in the pleadings. Would need to look
Okay.
back expressly at our answer. But certainly that was when the issue of fraudulent conveyance was the words fraudulent conveyance appear in the transcript towards the very end of the trial. And the court was
Okay.
treating that as an effort almost to amend, which I don't think was necessarily the way to do that. And of course, the appellant says, well, they didn't raise this, they haven't raised it on appeal, but I don't think it had to be raised on appeal. It was it was in the record, it was in the context, it was brought in for those reasons. And we're not appealing the court's denial of our effort to amend our pleading to indicate those things. That evidence is in the record. It's in the exhibits, and I think it's in the trial transcript as well. The Greens admitted that that's what they were doing. They knew that foreclosure was coming. The proof is in the record. So to say that it wasn't in there, that's why we brought all those various things in now. So I think revisiting the record will show that. The Trents, if I may just return just quickly to the facts here, the Trents and the Greens were not entirely unfamiliar with one another prior to this. In fact, the Real Estate Holdings of East Tennessee had a deed of trust against these very parcels in 2014. The Greens were, I think the Trents may have done some owner financing for the Greens, and eventually that deed of trust was released. Now, the interesting thing about that deed of trust is that it was signed by Adrian Green as president of ASG Holdings Management, which was the general partner of the limited partnership Real Estate Holdings of East Tennessee. And it also and he was also a limited partner in that same enterprise. So we mentioned a little bit about recourses of action. The Greens best that Mr. Trent could convey to the Real Estate Holdings was his marital interest in the tenants by the entirety. Real Estate Holdings could only convey what it had to convey, which was the marital interest down the chain. Then Real Estate Holdings could only convey to the Trents what it had to convey. So the Trents, by signing the deed of trust to Civis Bank, breached the covenant of the warranty of title involving when they represented that they had a. So Civis Bank had recourse against their grantor of the deed of trust, just as the Trents had recourse against Real Estate Holdings for violating the covenant of the warranty of title and the warranty deed it conveyed when it said we have a full fee to convey, and they certainly did not. So the effort to go back, and I think the fact that Mrs. Green, the appellants know that it was important, the fact that she wasn't included on the original quitclaim deed, because they had her do a subsequent corrective deed. By doing the corrective deed, they effectively acknowledge that she had to be a party. She had to assent. She had to be involved in the conveyance, and she was not. So I think that's an important point that that I don't want to let slip by.
This is Justice Kirby, Mr. Hurrett. I noticed that the deed of trust you're talking about, the 2014 deed of trust, has specific language. It says preparation of this document does not imply any representations by the preparer concerning the titleity to the described realty. So the Trents at that point are acknowledging that they have blinded themselves to whatever a title search might have uncovered to them.
I would agree with that point. My conclusion is that when the deal was being done between the Trents, Real Estate Holdings, and Civis Bank as the lender, that instead of doing a full title exam back up the chain to the source deed A, that they went back to the prior deed in the chain and missed the corruption of Mrs. Green being left off the chain, and thereby missing that. That's what led to this circumstance and situation. So by the bank's recording, Mr. Phillips made reference to the Holiday Hospitality case and said that there have been instances when third party or lien creditors have been reformed over top of. Well, the Holiday Hospitality case, the facts are not analogous to the present case. In Holiday Hospitality, you had a deed of trust holder who inadvertently released the lien of its deed of trust, which allowed a junior lien holder, a judgment credit lien holder, to improve its position in the registrar's office. That's not what we have in this case. The deed of trust holder is subordinate in this case. their lien of deed of trust was recorded after the judgment liens of the banks in this case. So I don't think holiday hospitality factually an analogy cannot be made between those situations. And because of that, I don't think that they can reform back over top of this intervening judgment liens. Now, you can say, is it fortuitous that this happened, that she was left off this one particular deed? Certainly, but why else do judgment creditors record their judgments in various registrar's offices around the state of Tennessee? We cast the net at times hoping to reel in the fish. Occasionally it's just boots and license plates and other things that come out of the water, but every now and then you might get lucky and land on something. And in this case, that's, I think, exactly what happened here. Now, someone might inherit property, someone might inherit something else that comes along the way. So we put our liens in the county where the property sits, and it just so happened this is what occurred. Now, going back to the holiday hospitality case, the remedy that was being addressed in that particular case was not reformation, it was actually cancellation of an instrument. And the appellants in this case want the court to kind of shoehorn that into a reformation argument. And I think it's trying to fit the proverbial square peg into the round hole. It just simply does not work.
Mr. Hewitt, this is Justice Page. What is your position about what the prevailing rule is in other states on this issue?
I'm glad you brought that up, Justice Page, because Mr. Phillips had made reference to a case in Florida where he said that reformation was allowed in a particular circumstance. This was the case of, I have the citation right here, is Smith versus Royal Auto Group. It's 675 Southern 2nd 144. It's a 1996 Florida Court of Appeals case. The difference between that case and our present case is that in that situation, there was a missing signature. And the Florida Court of Appeals relied on CJS reformation of instruments to say that a instrument can be reformed to include a omitted signature when that party intended to sign the documents. Now, there are cases in Tennessee that have held a missing signature, if the party intended to sign, is allowable. But that's not what we have in this case. We have a party that is seeking to add a brand new party and thereby create a new agreement, which is different than what the antecedent agreement was. So what we're saying is that I'm sorry, Justice Clark, you look like you had a question. I just want to make sure
I did, but I didn't want to interrupt because I think you may be answering it. Aren't in the Florida case and others you're referring to situations where the person was referred to in the document as a transferor and there was actually a signature line for that person, there just was not a signature. So the intention to convey was clearer.
That is correct. Yeah. That's right. And the question I have here is the appellants argue that it is undisputed that it was the appellant's intent, or excuse me, the Green's intent to absolutely and fully convey all of their property. But as we know with reformation, it requires a clear and convincing standard. Now, how would one go about disproving that since the Greens were only arguing with themselves? Or I mean, the Greens were only agreeing with themselves, if that makes sense. They control both sides of the closely held transaction. This was not a circumstance where you had arm's length transaction where consideration was being exchanged. This was a situation where there was no consideration given. There wasn't even a written agreement. There wasn't even a written antecedent agreement from which to prepare these deeds. These were just being done so that they could jettison these properties off as quickly as possible, shelter them in order to hinder their creditors, which are our clients, the appellee banks, and to better shield those properties. So I think in this situation, when you go back and try and say versus making an argument about the material change to the written agreement, adding a whole new party creates a whole new agreement. Now, as your learned predecessors in the Court of Appeals acknowledged that only the parties to the written instrument can acknowledge that there's been a mutual mistake. And Mrs. Green was not a party to the instrument being sought to be reformed at this juncture. And therefore, how can she be said that she participated in the mutual mistake? She did not. And I think that much is clear. And I think that was also from the Holiday Hospitality case, which was cited by the Intermediate Appellate Court. It says, and I wanted to raise a further point from the Intermediate Appellate Court, which I agree with, is that it was irrelevant as to what Mrs. Green would testified to. She testified that yes, she intended to convey, but the deed between Mr. Green and Real Estate Holdings accomplished exactly what it set out to do. He was able to convey his marital interest in the tenancy by the entirety, and he accomplished that. The fact that she did not join in that, it was her interest to give away, and she needs to do that by separate instruments, which she later did. And so now if tenancy by the entirety was destroyed by their conveyance, and then her subsequent execution of the corrective deed transferred her remaining interest through Real Estate Holdings and by operative effect down to the Trents now, then we say it went with the judgment liens, and title has now been reunified in the Trents, subject to the judgment liens of the appellee banks.
So on the issue of fraudulent transfer, you're not trying to get anything voided, right? You're not asking for affirmative relief in terms of trying to get either the Greens transactions voided. You just want to, for the Trents not to be able to obtain affirmative equitable relief to reform the deed.
That is correct, Justice Kirby. Yes, we are not seeking that. Probably the reason why we didn't raise in that context, because the Greens were not parties to the initial lawsuit. The bad actors who started this process were not really there. They would have been the ones initially to really raise fraudulent conveyance against or other things like that. And of course, the banks had not set about really pursuing the execution of their judgment liens, because of course, at that point in time, we didn't know exactly what we had. But now that when this all came to light, the fact that we were sitting there with judgment liens recorded in hand, I think puts us in a superior position to the liens of Civets Bank and as well as the Trents. And the Trents took, or should have known, that they were taking subject to these judgment liens, and an appropriate title exam would have revealed that. And in Tennessee, being a race notice jurisdiction and balancing the equities, Tennessee, by winning the race to the courthouse, and I think the appellee banks in this situation should win the day if we're looking at balancing the equities. So I frame the issue in my mind. I just can't get past the fact of the bad acts that precipitated this whole process. And by dealing with those and looking at the inequitable acts that started this process, how you can come in now and seek equity, even knowing even if the Trents weren't the ones who jettisoned this property or attempt to hide this property or anything else. As they say, certain things flow downhill, and that is truly applicable to the chain of title in this situation as well. So by accepting and trying to say that they have standing to avail themselves of the equitable remedy of reformation, the appellants also have to accept the sour spoonful that comes along with that, which is they cannot scotch back over or reform back over top of this and now seek equitable relief. As Justice Kirby had indicated, they're seeking extraordinary equitable relief, and we simply just don't think that that's available in this particular case.
You think they could have, the deed could be reformed, but would still just be subject to the judgment liens? Because at some point this deed needs to be fixed. So if there's reformation allowed, but subject to the liens, then your client still prevails, and then the Trents end up with complete title, subject to probably large liens that make it difficult. Is there any basis for that kind of holding?
I don't believe so, Justice Lee. And the reason why I say that is because I think that they accomplished that by the initial conveyance from Mr. Green to real estate holdings down to the Trents. His interest is down into the Trents now. They were holding that interest prior to Mrs. Green's conveyance. Mrs. Green's subsequent conveyance, which already had the judgment liens glommed onto it at that point in time, when she did her corrective deed was effective. No one is saying that. She conveyed her interest down to real estate holdings, and I think by the deed of the doctrine of after acquired title, by operative law, her interest flowed from real estate holdings down to the Trents as the current owners, where title was reunified subject to that. Now, obviously, the Greens did not. I don't think the Trents took as tenants by the entirety, and I'd have to go back and look at the deed, which is in the record, I believe, as to what interest they took or how they held it, whether it's tenants in common or otherwise. But it would be subject to that. So I'm not even sure Reformation really needs to enter the equation in order to get where you want it to go, Justice Lee.
So you don't object to the deed being reformed as long as your liens are still attached to Mrs. Green's interest. Is that right?
Well, certainly I want our liens attached to her interest, but if you reform, I'm not sure whether Reformation needs to come, because if title has been now unified in the Trents, there have been two deeds that were done. I'm not sure where Reformation needs to come into play in that equation. What is to be reformed if title has already been unified in the present owners subject to our judgment liens? That'd be my point.
I see what you're saying. So I mean, the Trents own the entire tract, including Miss Green's interest at this point, but your liens attach.
That is correct, Your Honor. Therefore, that nullifies any need, I think, for reformation in this circumstance.
I guess this is Justice Kirby. The only point of reformation would be to make the unification of the title retroactive back to 2010, which would place them ahead of your client, right?
And that's correct, and all the more reason why we cannot agree to the reformation.
Gotcha.
All right, with that, I see my time is winding down. I thank the court for the opportunity to present to you today, even if virtually, and I will yield to Mr. Schultz here as the timer runs out. Thank you very much.
Thank you very much, Mr. Hewitt. Mr. Schultz?
Oh, thank you, and good afternoon. I reserved 5 minutes because I just wanted to touch on the fraudulent conveyance issue, which you've covered quite a bit, but I wanted to point out, I was the one that raised it at the trial level at the end of arguments. But I just want to point out that there's no need to plead it at the trial level. It's not a defense. It's not a cause of action. The Greens were not even parties to the lawsuit. So I just want to point out the facts that are in the record are that Adrian Green had 40 years of experience in realty. His wife had some amount of experience that wasn't really stated. But the Greens admitted they were trying to transfer all of their property, and it turns out it was 12 total parcels there. They knew foreclosures were coming. They transferred their property to a related entity, and at least in the case of the property at issue here, there was zero consideration for it. So those are all elements of Tennessee Code Annotated 66-3305. And I don't think it needs to be pleaded as a cause of action or an affirmative defense. I was pointing out to the trial court, these are the facts, and this being an equitable solution that the petitioners were seeking, these facts go to the equities of the case.
This is Justice Clark, Mr. Schultz. So is your bottom line that we must review that issue, that we must address that issue?
I think it's—
Or is your bottom line that we could decide this case in your favor without really directly addressing that issue?
Well, I think you can for a different reason, which I'll get to in a minute. But I think that those are the facts in the record, and they were pointed out to the trial court. So I think that you can consider those facts. The reason why you don't need to consider them is this is a case of first impression, and you're going to be setting a rule for the state, and and I disagree with some of the things that have been said here. I think that the general rule in other states is that you cannot reform an instrument to add a party whose name appears nowhere on the instrument. If you allow that to happen, you open the door for a lot of uncertainty. For instance, title searchers, attorneys searching titles would never be certain that there couldn't be another party added later on, which is a real issue there. So that's really all I wanted to say. I think Justice Kirby, for some reason, people have a reaction to the term fraudulent conveyance because, fraud sounds like a criminal act. And when it comes to fraudulent conveyances, it's really a term of art. And if you look at the statute, it doesn't just mean fraud. It means debtor trying to transfer property to hinder, delay, or defraud their creditors. So it's really just a debtor trying to put their property beyond the reach of their creditor. So
the trial court make a finding of fact that this was, in fact, the Green's motive was to put that property beyond the creditors?
I think the court could do that.
The trial court did not.
Oh, the trial court did not make that finding. The trial court,
I'm not sure how we can, because that would be a finding of fact that the fact finder should do, not the Supreme Court, correct?
I understand, Your Honor. The trial court merely held that she didn't think that she could reform a contract to add a party to it. And I think that should be the rule, the general rule. So unless there are any questions, I'm finished.
All right. Thank you, Mr. Schultz. Mr. Phillips, we'll hear you on rebuttal.
Yes, I find it interesting that the thrust of the respondent's arguments are about issues that were not raised in the pleadings, that there was scant testimony and were not raised in any argument until right at the end of closing arguments, when the judge immediately said, I'll not consider that, that hasn't been raised. But that's the thrust of their argument. Reformation is fairly clear. The Doctrine of Reformation nowhere says that you can't reform a contract by adding a party if in fact the original agreement was that that person should have been a party. As I say, where do you draw the line? Justice Lee asked a question, were there questions about the Trent's knowledge of any of this? And no, there were not. There were no questions about the Trent's knowledge. And in fact, the Greens, who did testify, certainly did not admit that they were transferring this property to defeat creditors. They said they were transferring this property because they owed, I think, the general partner of the limited partnership a debt, something in the nature of $600,000, and that they transferred the properties because of that. It seems interesting to me. And then the question of, can you do this when only the Trent's when only the Greens testified? The standard is you must find clear and convincing evidence, which is what Judge Stanley found, clear and convincing evidence that Mr. and Mrs. Green intended to convey their interest, that the limited partnership intended to receive that conveyance, and that there was a mistake made by the attorney and consequently a mutual mistake between the parties because they thought that it had been conveyed and that the conveyance had been received and it had not. It's a classic example of reformation, of the equitable remedy of reformation. To come into now to the Supreme Court of Tennessee and raise these issues about fraudulent conveyance when they were not raised, and I believe they should have had to be raised in the pleadings. I believe that is an affirmative defense. They were not, and they were nowhere raised in the pleadings. I think the sole issue is whether or not you can reform a deed by adding a person that was intended to be a party, but who was inadvertently excluded. I think as far as the intervening creditor is concerned, I disagree that holiday hospitality doesn't apply. It applies It was decided on the basis of reformation. The court talks about it, the equitable remedy of reformation, and the fact that a judgment creditor is not one that can be prejudiced by reforming an instrument, because the judgment creditor is not a bona fide purchaser. They have given up nothing. They will lose nothing. They will be in the same position they were in when they filed their judgments, had in fact Mrs. Green's signature and name been on that deed, which it should have been. Not for any fault of their own, of the conveyors.
Mr. Phillips, this is Justice Bivens. Let me ask you a question along those lines then. There were 12 deeds that were, there were 12 pieces of property that transferred here, correct?
That's correct. That's correct.
Okay. Was Ms. Green a party to all 11 of the other?
No, they were mixed. I can't give you the exact numbers. Some tracts, Mr. Green was the sole title holder. Some tracts, Mr. and Mrs. Green were both on. All the rest of the properties were correctly done. It's just that this one was mistakenly drafted by the attorney, and that's where the mistake occurred. And if there are no other questions, then I have finished, and I thank you for your attention.
All right. Thank you very much, gentlemen. I think that will conclude our argument here today. Again, we very much appreciate your willingness to participate in this manner. We're happy we were able to bring this to folks in Tennessee and elsewhere by way of live streaming today. So again, thanks for participation. We appreciate it. And we will now have court stand adjourned. Thank you.
Thank you.
Court is now in recess.